They put the handcuffs on him at 12 minutes past midnight on a wet Virginia road, and the officer who reached through the open window of that brand-new Lexus, yanked the heavy door open, and grabbed the shoulder of the man inside had absolutely no idea that in less than 10 hours, that same man would be sitting at the most powerful judicial bench in the United States, deciding cases that shaped the lives of 300 million people. He had no idea, and that was the whole story. The officer did not ask himself why the man had rolled down all 4 windows the moment the lights came on. He did not ask why the interior dome light was burning white and bright, or why both hands were spread wide at 10 and 2 on the steering wheel, with every finger visible. He did not ask any of these questions because he had already decided what he was looking at before he left the cruiser, and a man who has already decided does not ask questions. He collects confirmation. He collected it. He snapped the cuffs on. He drove away feeling like a man who had done his job well. In less than 9 hours, he would be standing in a courtroom listening to a judge read his own words back to him from a sworn document, and the feeling he had in that moment would be something entirely different. But right now it was cold and dark and quiet on Georgetown Pike in McLean, Virginia, and the rain was coming down in thin gray sheets, and the obsidian Lexus sat on the gravel shoulder with its interior light still burning, and the pharmacy bag on the wet hood, and the car was empty, and the night continued. Roland Mercer had been thinking about the Fourth Amendment when the lights appeared in his rearview mirror. Not because he was nervous, and not because he had any premonition of what the next several hours would bring. He was thinking about it the way he thought about it most of the time, which was to say constantly and with a specificity that people outside the law found exhausting, and people inside it found either admirable or slightly alarming depending on their orientation. He had spent 35 years inside the law, and the law had gotten into everything the way water gets into old houses, finding every crack and settling there until it is simply part of the structure. He was 67 years old, broad-shouldered gray at the temples, and he was wearing gray sweatpants and a worn Georgetown law hoodie with the hood pulled halfway up against the November drizzle because he had slipped out of his house at 11:30 at night to pick up his wife's medication and had grabbed the nearest comfortable clothes he could find. He was driving a 2025 Lexus LS 600 in obsidian black, which he had bought 3 months ago as a quiet acknowledgement that he had reached the age where heated leather seats on a cold night were not an indulgence but simply a reasonable accommodation to the body that had carried him this far. For 4 years he had served as an Associate Justice of the Supreme Court of the United States. Tonight he was just a husband running an errand. Evelyn had developed a severe migraine after dinner. Her specific prescription had run out 3 days ago, and she had only remembered tonight when the pain arrived. The pharmacy on Leesburg Pike was 24 hours. Roland had told her to stay in the dark bedroom, pulled on the nearest comfortable clothes, grabbed the keys, and slipped out into the rain. As he glided back toward their home in the reserve, he was turning over the nuances of a case sitting on his desk. A case brought by a man named Terrell Boyd, who had been stopped in Prince George's County for driving a clean car at 2 a.m, searched without consent, charged with possession of a firearm that his attorney argued was planted. The Fourth Amendment question at the center of the case was one Roland had been wrestling with for 6 weeks. At what precise moment does a hunch become reasonable, articulable suspicion? And what is the cost when we get that calculation wrong? He did not yet know he was about to find out from the inside. He caught the cruiser in the rearview mirror only briefly, a shape parked under the awning of a shuttered gas station angled in a way that was less about shelter from the rain and more about sightlines. A small and practiced tightening moved through his chest. Not fear. Recognition. He had heard this described in 1,000 intake interviews from 1,000 men in plastic chairs across a scarred wooden desk in a Baltimore public defender's office, and he had always understood it intellectually. He kept his speed at exactly 35 miles an hour. He drove. Wayne Crowell had been chewing the same piece of gum for 40 minutes, working it with the slow, deliberate jaw movement that his partner Marcus Webb had learned in 6 months of riding together to interpret as a warning sign the way certain animals flatten their ears before they bite. Crowell was 42 years old, thick-necked with a jaw that looked engineered for chewing, and a face that had been described by various police supervisors and complaint board adjudicators over the years as intense, aggressive, proactive, and old school, depending on who was writing the form and what they were trying to avoid saying directly. He had been on the Fairfax County Police Department for 14 years. He had 23 formal complaints against him. 21 of those complaints had been dismissed by his division supervisor, Captain Hal Greer, a man who played poker every other Thursday with the county police union president and who had a particular gift for transforming the documented accounts of frightened citizens into administrative anomalies that dissolved before reaching any review board. The remaining 2 complaints had been sitting in the administrative review pipeline for 14 months, classified as pending additional documentation, which in Captain Greer's department was a category with no defined deadline. The habit that had given Crowell his reputation among his colleagues was the way he tapped his badge with 2 fingers whenever he was about to assert himself. A small unconscious percussion that preceded every confrontation the way a musician counts himself in before a song. He did it right now. Sitting in the parked cruiser in the rain, his eyes on the empty road, the 2 fingers tapping lightly against the silver shield on his chest. Marcus Webb was in the driver's seat running plates on passing cars the way he always did, because Crowell never ran plates before a stop, and Webb had decided early in their partnership that one of them should. Webb was 26 years old and had been on the force for 6 months, and still wanted genuinely and without irony to be a good cop. He had grown up with a father who coached high school football and a mother who taught 3rd grade, and he had an older brother who was a paramedic and a younger sister in nursing school, and the family had a general orientation toward public service that Webb had inherited. He had gone to the academy because he believed in it. He was finding out in the passenger seat of Cruiser 7 Delta on a cold November night what believing in something costs when the institution you joined does not share the belief. 2 weeks earlier, Crowell had said something to Webb that he had written down verbatim in his personal notebook because the precision of it bothered him more than a general statement of prejudice would have. They had been watching a black Mercedes pull into a private access road off Chainbridge Road, and Crowell had said, without looking away from the car neighborhoods like this have an ecology. Marcus and my job is ecological management. Some things belong here, and some things do not. The trick is learning to read the difference fast enough to act before the moment is gone. Webb had written it down. He did not know yet what it was worth. The Lexus appeared from the south, moving through the mist at exactly the speed limit, its headlights steady and well-aimed, its lane position flawless. Crowell leaned forward. The gum slowed. The 2-finger tap fired against his badge. "That is a 2025 Lexus LS 600, Webb said, looking at the passing car with the automatic assessment of a man who had been running plates all night. "Driving perfectly within limits." "Too perfectly," Crowell said, and his voice had the flat certainty of a man who has already made the decision and is now constructing the reasoning around it. "Nobody drives exactly 35 on this stretch at midnight unless they know they are being watched." Webb started to say that knowing you are being watched and obeying the speed limit was not evidence of a crime, but Crowell was already leaning forward, his eyes on the Lexus taillights. "Pull up alongside him," Crowell said. "I want to see the driver." Webb hesitated. "Derek," he said, keeping his voice neutral because he had learned that argument landed better than protest. "We have no probable cause. They are driving perfectly fine." I said. "Pull up," Crowell said, and the tone was the one that meant the conversation was over. Webb pulled out of the lot and accelerated south. The cruiser came up alongside the Lexus in the left lane, the 2 vehicles briefly parallel under the amber wash of a street lamp. Crowell rolled his window down, ignoring the cold rain, and stared across into the cabin of the Lexus. The dashboard lights were dimmed. The interior was mostly dark, but in the 2 seconds of lamplight, Crowell saw what he was looking for, which was also what he had already decided he would see. He rolled the window back up. "Stolen," he said. It was not impulsive what Crowell did next. That was the thing Webb would spend the next 3 years trying to explain to people who assumed it must have been a split-second mistake, a moment of poor judgment under pressure, the kind of error that better training could have prevented. It was not that. It was practiced. It was a calculus that Crowell had been running for 14 years, a formula so well worn in his mind that it no longer felt like a decision at all, just an observation of the obvious. The components were these: an expensive car, a black driver, a wealthy, predominantly white neighborhood, and the hour of midnight. He had never once stopped to examine the reliability rate, had never tallied the results and asked himself what each stop actually produced, had never placed his conviction record for those stops next to the total number of stops, and looked at the ratio honestly. The formula felt true. Feeling true had always been enough. He told Webb to hit the lights, and Webb did not move. Webb was at the mobile data terminal keyboard, his fingers flying. "Derek," he said, "give me 20 seconds to run the plate." Crowell reached across the console and flipped the switch himself. The light bar exploded into red and blue, painting the wet road and the mist and the dark trees in rotating color, and Crowell watched the Lexus with the focused satisfaction of a man watching a trap close. The Lexus did not accelerate, it did not swerve. The turn signal came on immediately, that amber blink ticking with calm, methodical compliance, and the vehicle moved smoothly to the right and pulled onto the wide gravel shoulder and stopped. Webb stared at the car. "People who are running do not signal," he said quietly. Crowell was already unclipping his seatbelt. He checked his mag light. He reached down to the retention strap on his holster and unsnapped it, which was an escalation with no basis in the situation, but which Crowell performed without thinking about it, the way you test the safety on something you might need in a hurry. Webb's screen came back with the first layer of the result. He saw the words "registered and clean" before the connection froze, and the system began loading the secondary layer. He saw the beginning of the words "federal judicial," and then the screen locked up the spinning wheel of a slow government database, doing its work at its own pace. Derek Webb said, "The plates are coming back. There is something on this registration. You need to wait 1 minute." "I have the driver," Crowell said, and pushed the door open and stepped out into the rain without looking back. Webb sat for a moment in the driver's seat, the terminal spinning, watching Crowell's broad back moving toward the Lexus with the particular gait of a man who owns the ground he is walking on. He pressed refresh. He opened the secondary channel to the dispatch database and began typing the plate number again from scratch. He looked up. Crowell was already at the rear quarter panel of the Lexus, approaching from the passenger side, positioning himself behind the B-pillar in the tactical stance he had used 1,000 times. Webb got out of the car. The stomach drop was real and immediate, the kind that bypasses the intellect entirely and lives in the body at a level older than education, older than 35 years of legal training, older than every principle Roland had ever committed to memory or argued before a court of law. He was a black man in America, and there were police lights in his rearview mirror on a dark and empty road at midnight, and his body knew what that meant before his mind could finish the sentence. He let the feeling move through him. He gave it exactly 3 seconds. Then he reached up with his left hand and flooded the cabin with bright white light from the interior dome. He pressed the buttons for all 4 windows. The cold, rain-wet air came in immediately, raising the smell of wet asphalt and November leaves. He placed his hands at 10 and 2 on the steering wheel, fingers wide and splayed so that every finger was visible from any angle. He pressed the push-to-start button with the heel of his right palm and killed the engine. Then he sat perfectly still and waited. He had rehearsed this not as a drill, but in his mind many times, the way you rehearse any procedure you hope never to need but cannot afford to be unprepared for. He had learned it from his clients, from the young men who sat across from him in the intake room in Baltimore and described in their specific and often very precise terms what had worked and what had not, what had kept them breathing and what had cost them a night in the emergency room or 3 years they would never get back. Do not reach for anything. Do not argue at the roadside. The courtroom is the place for the argument. The roadside is not. The officer came to the passenger side first. Roland kept his eyes forward. The maglite hit the side mirror, first filling it with blinding white light, and then the beam swung through the open window and found his face. Roland did not flinch. He looked straight ahead and kept his hands exactly where they were. "Good evening," Officer Roland said, and his voice was exactly what it always was. The deep, resonant baritone that had quieted courtrooms and commanded the attention of sitting attorneys general and a sitting president on 3 separate occasions. The officer did not return the greeting. "License, registration, and proof of insurance," he said, and the words were not a request. They were a series of commands delivered in a tone designed to establish immediately who held the power in this conversation. Roland kept his hands at 10 and 2. He explained carefully and without apology that in his hurry to pick up his wife's medication, he had left his wallet on his desk at home. He said the registration and insurance documents were in the glove compartment on the passenger side. He said he lived 2 miles away in the reserve. He provided his full name. He offered his date of birth and his social security number for verification through dispatch. He said, "If you run the plates, you will see the vehicle is registered to me." The officer shined the maglite beam directly into Roland's eyes and held it there. "Left your wallet at home," the officer said, and the laugh that followed was short and specific, the laugh of a man whose conclusion has just been confirmed. "You expect me to believe you live in the reserve?" Roland kept his voice at exactly the same temperature. He said, "I assure you that I do, officer. The plates will confirm it. I am happy to wait while you run them." There was a pause. Then the officer leaned closer to the open window, and Roland could smell coffee and spearmint gum, and the officer said, "Guys who look like you do not own cars like this in neighborhoods like this. That is not something I need a computer to tell me. That is something I know." The sentence hung in the cold, rain-wet air between them like a thing with weight. Roland had heard variations of this sentence for most of his adult life in different registers and different contexts. He had read it in deposition transcripts of 30 cases. He had cited it in 4 opinions. He had explained to law clerks and to justices and to legal scholars what it meant when a sentence like that was spoken by a man with a badge and a gun in the dark on an empty road. He had never heard it aimed at himself before. He discovered that it felt exactly the way his clients had always told him it felt, like a door closing in a room you thought you were allowed to be in. He said in the precise and deliberate cadence of a judge addressing hostile counsel officer, "I have identified myself. I have identified the vehicle. I am fully compliant. I strongly suggest you return to your cruiser, run the plates, and verify the facts before you take any further action." The calmness was the specific thing that broke Crowell. He had been in this situation hundreds of times over 14 years, and the variable he had come to rely on, the one that confirmed his authority and made the equation work, was the fear. The trembling hands, the high, tight voice, the eyes that would not meet his. Those responses told him everything he needed to know about the transaction that he held, the power that the person understood, the power that the natural order of this particular moment was correctly arranged. Roland Mercer was not afraid. He was not trembling. His voice had not changed registers once. He sat with his hands at 10 and 2 like a man who had all the time in the world, and he spoke with the measured, unhurried precision of someone who had already decided how this was going to go, and was simply moving through the necessary steps to get there. From the other side of the car, Webb called out, "Derek, man, let us go run his info. The plates are trying to come back. Just give me a minute." His voice had the slight elevation in pitch that meant he was seeing something Crowell was choosing not to see. "Shut up, Toby," Crowell said without looking away from Roland. He leaned into the open window. His 2 fingers tapped the badge. He told Roland to step out of the vehicle. Roland was still for 3 seconds. Then he said in the same unhurried voice that he would comply under protest, and that he was placing the officer on notice that this detention lacked any reasonable articulable suspicion or probable cause, and that he was asking for a supervisor to respond to this location. "You do not get to ask for anything," Crowell said. "Get out." He did not wait. He reached through the open window, found the interior door panel, pressed the unlock, and wrenched the driver's door open with enough force that the heavy hinges strained against the motion. He grabbed Roland's left shoulder. Roland said clearly and firmly, "I am stepping out." He pulled his shoulder back from Crowell's grip with a controlled motion, unclipped the seatbelt himself, and swung his long legs out of the vehicle, planting his feet on the wet asphalt with deliberate steadiness. He stood. At 6'2", with the upright posture of a man who had stood before the most powerful room in American law for 4 years. Roland Mercer's full height in the rain and the red-blue light was significant. Crowell, who was 4 inches shorter and standing on the slight downward slope of the gravel shoulder, found himself looking up. This did not improve his disposition. "Turn around and face the car," he said. "Hands on the roof." Roland turned. He placed both palms flat against the cold, wet roof of his own vehicle, fingers spread. Crowell kicked his feet apart from behind a sharp lateral shove to each ankle that nearly took Roland's balance on the slick road, and began the search, rough and purposeful, the full-contact invasion of personal space that Crowell had used so many times it had become indistinguishable from habit. Roland's mind was working its own separate track. He was cataloging. Unlawful stop, no reasonable articulable suspicion documented or stated. Unlawful search, no consent given, no probable cause established. Battery. He noted the time in his memory with the precision of a court reporter noting the record. Crowell found the pharmacy bag in the front pocket of the hoodie and ripped it open. "What is this?" he said, and the tone implied he already knew. "It is blood pressure medication for my wife," Roland said. "From the 24-hour pharmacy on Leesburg Pike. The receipt is in the bag." Crowell dropped it on the wet hood of the Lexus without returning it. He reached for his handcuffs. Webb appeared at the front bumper. "Derek," he said, "the MDT result. There is a federal flag on this registration, a judicial officer flag. I have it right here on my phone. You need to look at this before you go any further." Crowell did not look at the phone. He looked at Webb with the specific dismissal of a man who has decided that evidence contradicting his conclusion is not evidence, but interference. "If the plates flag a judicial officer," he said, turning away, "that means this man stole a judge's car. That makes the charge better, not worse." Webb stood at the front bumper, holding his phone, looking at the back of Crowell's head. He looked at Roland, who was standing with his palms flat on the wet roof, not moving, looking straight ahead at the dark trees beyond the road. Crowell pulled Roland's left wrist from the roof, bending it behind his back, and Roland did not pull away. He simply moved his arm with Crowell's pull, rather than against it, which was the one thing you could do to reduce the chance of injury. Compliance without surrender. The lesson that had come through 100 intake interviews and now arrived in his own body on a dark Virginia roadside at midnight. Crowell closed the first cuff. The ratchet clicked 3 times, each click precise and deliberate, tightening down against Roland's wrist bones. Then the right wrist pulled back and joined to the left, and the second cuff closed with the same 3 clicks. The sound echoed in the wet night like something small and final. Roland spoke one last time before being walked to the cruiser slowly and deliberately, as though the air itself were a court reporter. He stated Crowell's badge number from the nameplate visible in the door light. He stated the time, 12 minutes past midnight. He stated the location, Georgetown Pike, at the junction of the Briarwood Access Road, McLean, Virginia. He said, "I am being placed in restraints without probable cause and without any documented reasonable, articulable suspicion for the underlying stop. I am requesting a supervisor respond to this location immediately." "You can request whatever you want," Crowell said. "It will not help you." Roland was walked to the rear door of the cruiser. He was tall and his hands were cuffed behind him, and the geometry of folding himself into the back seat required a forward lean that put strain on his restrained wrists. But he managed it without stumbling and, without assistance, lowered himself onto the hard plastic bench and the door closed behind him. Through the scratched, rain-streaked window he could see Webb and Crowell on the shoulder of the road arguing. Webb was pointing at his phone, his body language past polite suggestion and into something close to pleading. Crowell was dismissing each gesture with the flat wave of a man who has not lost an argument with a partner in 14 years and does not intend to start. Eventually, Webb stopped gesturing. He looked at the ground for a moment. Then he walked to the driver's side and got in without saying anything else. In the back alone in the dark, with the lights strobing through the cage wire and the cuffs tight against his wrist bones, Roland took one long, slow breath and then sat with it. The indignity of the situation, the precise and specific quality of what had just happened to him on his own road 2 miles from his own house. It burned. He had not expected it to burn this much. But underneath the burn, the decision was already forming clear and cold as the rain on the roof of the car. He could end this with one sentence. He could say who he was. Crowell would not believe him, but Webb would, and Webb would call it in. And within 20 minutes, someone senior would arrive, see the situation clearly, and the whole thing would dissolve into embarrassed apologies and a quiet disciplinary note that would be buried in Captain Greer's review queue and emerge in 14 months as an administrative anomaly. Crowell would keep his badge. The pattern would continue. The next Terrell Boyd and the next Bobby and all the men who came after them would have no protection that had not already failed them before. Or Roland could ride this all the way into a courtroom. He could let Crowell write his sworn affidavit. He could let the system process him through its machinery and stamp its name on every step. He could let it all happen in front of a judge under oath on the record, where it could not be quietly buried or reassigned or allowed to dissolve in the pipeline. He thought about his client, Marcus Hill, 22 years old in the summer of 1989, who had saved for 18 months to buy a used Buick and could not produce the purchase receipt during the stop because it was in his apartment and the officer did not want to hear about the receipt or the apartment. Marcus spent 3 days in a cell. He lost the Buick to impound fees he could not pay. He lost his job at the restaurant because he missed 3 shifts. He tried to explain this to 3 different people in the system, and every one of them told him he should have had his paperwork with him. Marcus Hill could not call anyone at 3 in the morning. He had no charcoal gray suit in his closet. Roland looked at his bruising wrists in the dark of the back seat. He was not going to give Crowell the easy way out. The cruiser pulled away from the shoulder, and behind them, the obsidian Lexus sat on the gravel with its interior light still burning and the pharmacy bag on the wet hood and the rain coming down. And Roland leaned his head back and closed his eyes and began composing the opening paragraph of a Fourth Amendment opinion in his mind, word by careful word in the dark and the cold, until it was exactly right. The Sally Port of the Fairfax County Adult Detention Center smelled of industrial cleaning fluid, and something older beneath it, something human and defeated that no amount of bleach had ever fully reached. And the fluorescent lights overhead were the specific cold white of lights, designed not for comfort, but for visibility, the kind that found every line in a face and left nothing anywhere to hide. Sergeant Dale Briggs was at the intake desk reading something on his monitor with the expression of a man counting down to the end of something, probably his shift, possibly his career. He looked up when Crowell walked in with Roland. "What do we have?" Briggs said. "Grand Theft Auto," Crowell said, and the confidence in his voice was the confidence of a man delivering good news. "Stopped him on Georgetown Pike, brand new Lexus. No ID, no explanation, that holds up. Playing the silent game. Probably has warrants in Maryland." Briggs looked at Roland. He saw what the context asked him to see: an older black man in wet sweatpants and a soaked undershirt, hands cuffed behind him. No wallet, no identification, no credentials visible. He asked for a name. Roland looked at him directly. "My name is Roland Mercer," he said. "The vehicle I was driving is registered in my name. I am invoking my right to remain silent, and I am requesting my phone call to contact my attorney." Crowell gave a short, dismissive sound. "He also claims to live in the reserve. Put him down under the registration name for now. Run his prints through the system. Whatever his real name is, we will find it." Webb had followed them in and was standing slightly to one side. "Sergeant," he said, "when I ran the plates, there was a federal flag on the registration. A judicial officer flag, I think we should. I think Crowell said over him that you should focus on your portion of the incident report and let the sergeant do his job. Briggs sighed the sigh of a man who has 2 years and 8 months left until his pension vests and has learned that the line between his business and not his business is a very important one. All right, he said. Empty your pockets, Carter. Take off the hoodie. Step over to the scanner when you are ready. The process was efficient and indifferent, which was its own particular kind of cruelty. Roland's wedding ring came off the one Evelyn had placed on his hand in a church in Baltimore 38 years ago and went into a labeled plastic bin. His watch went in beside it. The damp hoodie went into a property bag. The pharmacy bag was logged as personal effects, the bottle of Evelyn's blood pressure medication still undelivered. He was left in his white undershirt in the air conditioning of the booking room, which was set to a temperature that seemed chosen for its symbolic value rather than any practical purpose. The fingerprint scanner rolled his thumbs and each finger across a glass plate. He submitted to this without comment. Then the mugshot. The booking officer gestured him toward the gray wall and told him to look at the lens. Roland walked to the wall. He turned to face the camera. He did not look away, and he did not arrange his expression into anything apologetic or resigned. He looked directly into the lens the way he looked at everything that required a decision, with the full, unfiltered weight of a man who knew exactly what he was doing and why, and the resulting photograph captured something that no mugshot in the history of that particular camera had ever captured before. It captured authority. Cell Block C, Briggs said. Morning arraignment. The corridor to the cells was long and low-ceilinged, and the noise hit like a wall the layered sound of 40 people in too small a space. Crowell walked Roland to the cell door and pulled it open. He told Roland to get comfortable. He said comfortable the way you say a word whose opposite you mean. He said you are not seeing the outside of a cell for a very long time. The door closed, the lock engaged. Crowell's footsteps faded. At the Fairfax County Precinct, Crowell arrived for his booking paperwork at 1:45 in the morning, walking in through the side entrance with the loose-limbed ease of a man who has just finished a satisfying piece of work. The night desk officer, a veteran named Sal, who had seen Crowell come in like this many times before, looked up from his crossword. Big collar Sal said more statement than question reading Crowell's walk. Professional-type Crowell said, pulling up a stool and reaching for the intake form. Lexus, brand new. Georgetown Pike. He paused to work his gum with the satisfied rhythm of a man replaying something good. Guy had no ID on him, no wallet. Claims he lives in the reserve. He laughed, short and certain. They always have a story. What is the charge? Grand theft auto. Crowell tapped the form with his pen and then tapped his badge with 2 fingers the way he always did when he was setting something in stone. He will be arraigned in the morning. I'm going to watch. He finished the paperwork in 12 minutes, submitted it to the overnight clerk, and drove home. He made a sandwich. He watched 20 minutes of television. He got into bed and fell asleep quickly. The sleep of a man with a clean conscience and zero doubt, which is to say, the sleep of a man who has arranged the world inside his own head with sufficient care that nothing from outside it can get in. He slept well. He had no idea that Marcus Webb was at his kitchen table at that same hour on his personal laptop, going through the Virginia State Court database and the Federal Judicial Directory with the growing certainty of a man who keeps checking the answer because the answer is too significant to accept on the first pass. He had no idea that Webb had called his cousin at the Virginia State Police at 5 in the morning and received in return 3 words delivered in a flat and serious voice: "Get a lawyer." He had no idea that the man in cell block C was composing a Supreme Court opinion in his head on a concrete floor. He slept well, and that was the last good sleep he would have for a very long time. The cell was 8 feet wide and 10 feet long with a poured concrete floor and walls painted the specific institutional cream that exists nowhere in nature and everywhere in confinement, and a single caged bulb overhead that cast yellow light on everything and made everything look approximately a century older than it was. 2 men were on the narrow benches along the side walls, both asleep or close enough. Roland stood in the center of the cell for a moment. He looked at the exposed toilet in the corner, the scratched metal shelf, the folded blanket on the floor. He had read about these conditions many times. He had cited conditions like these in oral argument, using the language of constitutional law to describe the specific failure of the state to maintain facilities meeting the minimum threshold of human dignity. He had used words like inadequate and substandard while sitting in a leather chair in a marble room with good light and excellent air circulation. He understood standing here in the cell at 12:45 in the morning in a wet undershirt that the words had not been wrong, but that they had been incomplete in a way that only being in the room could correct. He did not take the bench. He walked to the corner opposite the sleeping men, lowered himself to the floor with care for his restrained wrists, which Briggs had uncuffed in the booking room, but which were raw and tender, and marked with the beginning of bruising that would deepen through the night, and put his back against the wall and his knees up and sat. He closed his eyes and began the brief. This was what his mind did when he gave it a task to organize. It produced structure and sequence, and the particular kind of ordered clarity that had made him one of the better legal writers of his generation. The task he gave it now was this: catalog every violation in order, with the appropriate statute or precedent attached to each. Unlawful stop. No reasonable articulable suspicion under Terry versus Ohio. Unlawful search. No consent. No probable cause. No exception. Battery. Unlawful detention. Falsification of a sworn document in the arresting officer's statement. He went through them methodically, the way he had taught his law clerks to build a record, not leaving anything out and not embellishing anything in. Then he thought about his clients. Not the famous ones, the early ones from the Baltimore years, the intake room with its one window and its table with the uneven leg. Darnell Washington, 19 years old, stopped 6 times in 2 years in the same neighborhood, who had developed a stammer when speaking to anyone in a uniform that he had not had before. Terrence Graves, 24, who had been waiting at a bus stop and lost 3 teeth on the curb when he asked why he was being told to move. Bobby, whose last name Roland had been trying to remember for 22 years, the man whose case was reassigned before Roland could finish the intake interview. He was not those men. He knew that. He had every advantage they had not had. He would be out of this cell before sunrise. He would be home before most of the country ate breakfast. But tonight, in these hours on this concrete floor, he was as close to those men as he had ever been in his adult life, and it was important. It mattered. It was the thing you could not fully know from a leather chair in a marble room, no matter how carefully you read the briefs, and now he knew it in his body, and he intended to carry it back with him and use it for as long as he had a pen and a bench and something true to write. One of the sleeping men stirred. He turned over and looked at Roland sitting in the corner in the yellow light. He studied him for a moment without speaking. Then he made a small gesture, a slight lift of the chin that asked without asking whether Roland was all right. Roland nodded once. The man nodded back. He turned to the wall again. Roland sat with that for a while. The smallest human transaction in the smallest room, and it was more honest than anything else that had happened to him since midnight. At 3:15 in the morning, Corrections Officer Raymond Tate paused at Roland's cell longer than the standard check required. Something clearly not computing in his taxonomy of Tuesday night inmates, and then opened the door and told Roland he could make his phone calls. The phone bank was mounted on a cinder block wall in the corridor, 4 heavy steel receivers bolted at regular intervals, the plastic of each worn smooth by the hands of many people who had stood in this spot before him, and Roland picked up the nearest one and dialed his home number from memory. Evelyn answered on the 3rd ring. Her voice had the specific register she used when she was controlling something that wanted very much not to be controlled. Fear layered under steadiness, like a river under ice. She had been awake since a little after 1 in the morning, when 2 Fairfax County officers had knocked on the front door and told her the Lexus had been found unoccupied on the shoulder of Georgetown Pike, and could she confirm her husband was not home, and when she had said yes, he went to the pharmacy. They had exchanged a look she had spent the subsequent 2 hours trying to interpret. "Roland," she said, "where are you? Are you hurt?" He told her exactly where he was, exactly what had happened, and exactly what he needed from her in the way of restraint for the next several hours, and she listened without interrupting, which was one of the things he had loved about her for 3 decades. She was quiet for 2 seconds after he finished. Then she said, "I am calling the Chief Justice Roland. I am calling the Attorney General. I know 3 Washington Post reporters personally, and I will wake all 3 of them up right now," he said with the patience of a man who has explained the same principle many times to people who were not wrong, only incomplete. "If you make those calls, this officer goes home tonight with a reprimand. The department issues a statement expressing concern and reaffirming its commitment to fair policing. Captain Greer places a note in the file. In 3 months, the note is superseded by a favorable performance review. The next man who gets stopped on that road on a Tuesday night at midnight gets the same officer and the same cuffs, and there is no record that anything like this has ever happened before." The silence on her end was different this time. She was a retired federal judge. She had spent her career watching the machinery of institutional self-preservation work with a speed and efficiency that was never available when the direction was the other way. She understood what he was describing. She asked what she needed to do. "Call Calvin Drummond," Roland said. "Tell him where I am. Tell him to be at the Fairfax County Arraignment Court by 8 in the morning and not a minute later. And Evelyn," he said with a specific gentleness reserved for the things that actually mattered, "tell him to bring my suit." "The charcoal one," she breathed. She said she would be there with him. He said he needed her home safe, watching the news and trusting him. She said fine in the tone of a woman who had not been fine with something a great many times over the course of a long and honest marriage, and who fully intended to be disagreed with about it at a later date. He said he loved her. She said she loved him back. Then she said, "Roland, do not let them break anything that cannot be fixed." He said, "I will not." The second call went to Calvin Drummond at 3:30 in the morning, and the voice that answered was thick with sleep for exactly the duration of the sentence it took Roland to explain the situation. And then the sleep was gone entirely, and what replaced it was the sharp, predatory excitement of a trial lawyer handed a nuclear weapon. Calvin said several things in sequence, none of which were appropriate for a government-monitored phone, but all of which expressed with precision and economy his assessment of the intelligence level of the officer responsible. Then he said, "Tell me you have not told them who you are." Roland said he had not. Calvin was quiet for 3 full seconds, which was never quiet for Calvin Drummond. Then he said, "You are setting a trap." Roland corrected him mildly. He was simply allowing the Commonwealth to proceed with the course of action it had chosen. Calvin said he would be at the courthouse at 7:45. He asked whether Roland wanted the aggressive suit or the devastating suit. Roland told him the devastating one. Calvin said he would see him in 4 hours, and the line went quiet. Roland replaced the receiver. He thanked Tate. He returned to the cell, lowered himself to the floor in the corner again, and in the quiet of cell block C, with the snoring of the man on the bench as the only rhythm, he returned to composing the opening paragraph of his Fourth Amendment opinion word by careful word, building it from the foundation up until it was exactly right. The detention center at 7 in the morning was a completely different organism from the one that had processed Roland at midnight, not kinder exactly, but operating on the rhythm of a place that has to move a large number of human beings through a defined sequence of steps before the courts open. At 7:30, the cell block doors opened. Roland was handed an orange jumpsuit and told to change. He held it for a moment and then handed it back. The corrections officer told him it was not optional. Roland said he would remain in his current clothing. The officer escalated his tone. Roland's tone did not escalate back, it simply did not change, and after a moment the officer moved on. He rode the transport bus in his white undershirt and gray sweatpants, seated in the middle of the shackled chain, watching the Virginia morning through the scratched window. He noted the time every few minutes. He had a schedule to maintain. Meanwhile, Calvin Drummond's car pulled into the Fairfax County Courthouse parking lot at 7:58. He got out wearing a bespoke three-piece charcoal suit with a white pocket square, carrying a briefcase in genuine alligator skin that courthouse regulars recognize the way old soldiers recognize a particular rifle as the thing you brought when you intended serious and permanent damage to the opposing position. He walked through the courthouse without acknowledging anyone, turned left into the arraignment wing, pushed through the door of courtroom 4A and sat down at the defense table and opened his briefcase with the calm efficiency of a man setting up for work. Ada, Renee Stafford, who had been at the prosecution table since 7:15 with a cold coffee and a stack of files, looked up when Drummond sat down across from her. She looked at the briefcase. She looked at the suit. She looked at the file in front of her labeled Commonwealth versus Mercer John Doe, alias Grand Theft Auto Resisting Arrest. She looked back at Drummond. He had not acknowledged her presence. Renee Stafford had been doing this job for 3 years. She had never once seen Calvin Drummond walk into this room. Calvin Drummond did not do arraignment court. He did federal appeals and landmark civil rights cases, and the kind of work that ended up in first-year law school curricula 20 years later. She pulled the John Doe file toward her and read it again more slowly this time with a feeling in her chest that she would later describe as the specific sensation of standing on something that was about to give way. Courtroom 4. A was a room built for volume and not for ceremony, and it showed in every aspect of its construction the low ceilings and institutional carpet, and the gallery benches worn smooth by the weight of years of families sitting in them hoping for the best and usually getting something less. Judge Patricia Okafor had presided over this room for 11 years and had processed more arraignments in that time than she could estimate. She was 54 years old, sharp-faced and precise, with reading glasses she wore on a chain. She had argued one case before the United States Supreme Court a decade ago. She had won. She remembered the experience clearly, including the face of the justice in the second seat to the left, who had asked the most penetrating questions of the morning. Wayne Crowell was in the gallery's first row in civilian clothes, a blue fleece and dark pants, sitting with his arms crossed and his gum working at the steady, deliberate pace that was his resting state. He looked like a man who has made a good investment and is waiting for the return. His hand came up to his chest twice in the first 10 minutes, the two-finger tap finding the badge that was not there, the phantom habit of a man whose identity had been organized around a piece of metal for 14 years. Marcus Webb was not in the room. He was in the hallway outside with his back against the wall and his notebook pressed under his left arm, and he had been there since 8:10, and he was deciding something. The inmates came in from the side door at 8:15, shackled and linked. Roland was in the middle of the chain, and he walked the way he always walked, with a deliberate, unhurried posture that had nothing to do with the room he was in or the company he was keeping, and the white undershirt and the gray sweatpants and the ankle shackles were not entirely able to erase what the posture communicated, which was a man who had been in the most important rooms in the country and was accustomed to the weight of them. Calvin Drummond rose from the defense table. "My client," he said in a voice calibrated perfectly for the room, not loud, not soft, simply the precise volume required to be heard distinctly by every person present, is the gentleman in the second row of the jury box, and he is not a John Doe. He has been providing his correct identity since midnight. Judge Okafor looked at the man in the second row in the white undershirt and gray sweatpants. She looked at the file that said John Doe and Grand Theft Auto. She said, "Bafe, bring the defendant to the defense table, please." Roland was unshackled from the chain and walked across the well and stood next to Calvin Drummond. And he stood the way he always stood, with an absolute stillness that was not passivity, but its opposite, the stillness of a thing completely organized around a central purpose. Judge Patricia Okafor looked down at the file. She looked up at the defendant. She looked down at the file again. 5 seconds passed. The HVAC hummed. In the gallery, Crowell leaned forward slightly, still not understanding, still seeing a car thief with an expensive lawyer, the expensive lawyer confirming in his mind that this was organized crime, that he had been right, that the collar was good. Judge Okafor took her glasses off the chain and put them on and looked at Roland again. She looked at him the way you look at something you recognize out of context, the brain processing the familiar face in the unfamiliar setting and taking a moment to resolve the contradiction. The resolution arrived. Her face changed. The professional mask did not crack so much as it briefly suspended, held in place by the force of what she was looking at and the effort required to process it appropriately. She took her glasses off again. She placed them on the bench. She was quiet for 3 more seconds. Then, in a voice stripped of its courtroom cadence and replaced with something plainer and more human, she said, "Justice Mercer." In the front row of the gallery, Wayne Crowell's gum stopped moving. The 2-finger tap toward the missing badge froze in midair, and his hand hung there uselessly, neither touching his chest nor falling to his side, suspended in the moment between the world he had been living in and the one he had just arrived in, which were so different from each other that the transit between them had not yet registered as possible. And then the memory arrived unbidden and specific. The kind the body sends when it knows something the mind is still refusing to accept. The wet road at midnight, the interior dome light of the Lexus, burning white against the dark. The steady, unflinching baritone voice saying, "I have identified myself. I have identified the vehicle. I am fully compliant." The cuffs clicking tight against old wrists. The federal flag on Webb's phone screen that Crowell had waved away like an inconvenience. The way the man had stood up from the car to his full height, 4 inches taller, steady as a building in the rain. Crowell looked at the man at the defense table. He looked at the posture. He looked at the bruises on both wrists, catching the courtroom light. He looked at the face. Then Roland Mercer turned his head. Slowly and without urgency, he turned from the bench and looked at the gallery. He went directly to the first row, because he had known Crowell would be there, because he knew how men like Crowell were organized, what they needed to see, what drew them to the aftermath of their own actions. Their eyes met. Crowell held it for 3 seconds, and in those 3 seconds he experienced something he would not have words for later. The understanding that this man had known from the moment the cuffs went on, had known exactly what he was doing, and why had let Crowell write. The affidavit had let Crowell bring him here into this courtroom. In front of this judge, in front of all these witnesses, had let Crowell walk in this morning in his blue fleece to watch what he thought was a victory. Roland's expression was not angry. It was not triumphant. It carried the specific quality of someone who has seen exactly this dynamic many times before and has arrived today at the place where it ends. Crowell's legs gave. He sat back hard against the gallery bench, his hand finally falling from the empty space on his chest, and he held the railing in front of him with both hands and stared, and the gum which had been the external metronome of his confidence for 14 years was simply gone. Roland turned back to the bench. He looked up at Judge Okafor. He said in his deep and unhurried baritone, "Good morning, Judge Okafor." Calvin Drummond did not raise his voice once in the next 22 minutes. He did not need to. The documents did the work, and the documents were devastating. He began with the stop. He stated in the flat, unhurried cadence of a man presenting mathematics rather than argument that at 12 minutes past midnight on a Tuesday in November, his client had been pulled over on Georgetown Pike while driving at exactly 35 miles per hour with no traffic violation and no reported crime, and had been identified by the arresting officer as a suspect in a grand theft auto, based on no documented, reasonable, articulable suspicion of any kind. He said his client had provided his full name, his address, and his vehicle registration information within 30 seconds of the officer's first approach. He said the officer had laughed at this information. Judge Okafor set the file down and told him to continue. He continued with the mobile data terminal log. He placed a printed copy on the bench for the judge and one on the prosecution table for Stafford. And he indicated specifically the entry logged by Deputy Marcus Webb at 12:07 in the morning, 3 minutes before the stop was fully initiated, before the exit from the vehicle was ordered before the handcuffs were applied. The entry read in Webb's shorthand vehicle registration flag, Federal Judicial Officer Active Appointment, Article 3. Informed D.W. D.W. said, "Continue." He looked at the gallery and his eyes settled on Crowell with the calm surgical precision of a man who has located the subject of the operation. The arresting officer, he said, was informed by his partner with documentary evidence on the cruiser's own mobile data terminal that the vehicle belonged to a federal judicial officer 6 minutes before he applied restraints to my client. He chose to proceed anyway. He then filed a sworn affidavit in this court. Drummond picked up the affidavit. He read it aloud. His voice did not change register. He read the sentence about erratic driving, though the MDT log showed the vehicle had been traveling at exactly the posted speed limit. He read the sentence about furtive movements toward the glove compartment, though the MDT log showed that the stop was initiated before any such observation was possible. He read the sentence about physical resistance during removal from the vehicle. He read the sentence about furtive movements a second time. He placed the affidavit on the bench next to the MDT log and aligned their edges with great deliberateness so that the documents lay side by side, the sworn claim beside the contemporaneous record, the timestamp gap between them clearly visible. He said every material claim in this sworn affidavit is directly contradicted by this department's own records generated at the time of the stop, before my client was processed, before the affidavit was written, and before anyone in this chain of custody had any reason to alter them. The silence that followed was the specific silence of a room that has just understood something it cannot ununderstand. Judge Okafor's gaze moved to the gallery. "Officer Crowell," she said, "stand up." The man who stood up from the front row was not the man who had walked through the door 20 minutes earlier. The gum was gone. The hands on the railing were white at the knuckles. The face was drained. Judge Okafor read from the MDT log. She read the exact entry Webb had logged at 12:07 in the morning, the direct quote from the arresting officer, the sentence about people who look like you and cars like this and neighborhoods like this. She read it in the same flat judicial tone she used for everything. She read it and looked up. She said, "Officer, this is a direct quote from your partner's contemporaneous record. Do you deny saying this?" Crowell gripped the railing. He said, "I believed the vehicle was stolen. I was protecting the neighborhood." Judge Okafor said, "Protecting it from what precisely?" The answer that came out of Crowell's mouth was not a defense. It was not a justification. It was the thing you say when you have run out of the language of reasons and arrived at the thing underneath them. He was wearing a hoodie, Crowell said. He did not have his ID. That is standard police work. The 3 sentences fell into the room and lay there, clear and small and completely sufficient, doing more damage than any argument Drummond could have constructed, because they were true in the sense that they were what Crowell actually believed. And the gap between what Crowell believed and what the law required, and what human decency required, was in those 3 sentences fully visible and fully measured and could not be disputed. Then Roland Mercer stepped forward. He moved past the defense table and walked to the wooden railing that separated the well from the gallery and stopped 3 feet from where Crowell stood, and the room was utterly still. Roland's voice when he spoke was the voice of a man who has waited through a long night to say something that needed to be said correctly and has used the night well. He said, "Officer, you spoke of reasonable, articulable suspicion this morning, as though it is a technicality to be navigated around, rather than a constitutional protection to be honored. What you required of me to justify my presence on a public road in a vehicle I own in a neighborhood where I have lived for 12 years was not the law's standard. It was your standard, and your standard is not the law." He did not raise his voice. He did not step closer. He said, "I survived last night because I know what you were doing, and I have the resources to hold it accountable. I have Calvin Drummond. I have a suit in my closet. I have a phone number for people who will return my call at 3 in the morning. The man who does not have those things, the man you will stop next week on this same road, in this same way, What does he have? When you put him in those cuffs without cause, who does he call? When you write the affidavit about his furtive movements and his failure to comply, who reads it for him in a courtroom? He looked at Crowell directly. He said you had 23 complaints against you. 21 of them were never heard. That is not an accident. That is a machine that was built to allow exactly what you did last night to continue indefinitely. And I will spend whatever time I have left on the bench ensuring that machine is taken apart piece by piece. Crowell did not answer. There was nothing in his mouth to use as an answer. Roland turned back to the bench. He thanked Judge Okafor. He said the record should be transmitted to the Department of Justice Civil Rights Division and the Virginia State Police Internal Affairs Bureau before noon, not as a request, but as a formal notation of the court. He asked that the sworn affidavit be flagged for perjury review. Judge Okafor said it will be transmitted before noon. The perjury review begins today. And Justice Mercer, she said with the expression of a woman who has decided to say one true thing before the proceeding concludes, I am sorry that this was necessary. I am sorry it happened in my county. Roland said, I know you are judge. That is not nothing. Judge Okafor dismissed every charge against Roland Mercer with extreme prejudice. She said the phrase with an emphasis that suggested she was aware of every layer of its meaning and intended each one. Calvin Drummond, while Okafor was still writing the order, leaned across the aisle to Renee Stafford and told her in a quiet and conversational voice that a civil rights complaint under 42 U.S.C. 1983 would be filed within 48 hours and would name the arresting officer, his supervising captain, and the Internal Affairs Division that had processed and dismissed 21 prior complaints from the same officer over 7 years. Stafford looked at the face-down affidavit on her table and said she understood. The side door of the courtroom opened and Marcus Webb came in. He had been in the hallway for 22 minutes with his notebook under his arm, and the decision he had been making had worked its way toward completion, the way decisions do when you have delayed them past the point where delay is comfortable. He looked like a man who has crossed a threshold and is not going to try to go back through it. He walked directly to the bench. He introduced himself to Judge Okafor, gave his name and badge number and assignment to Cruiser 7 Delta. He said he was the partner on the stop the previous night. He said he had his personal notebook with him containing time-stamped entries and direct quotes from the arresting officer logged at the time of the incident, and he would like to submit it as a formal statement to be made available to state investigators. He placed the notebook on the bench in front of the judge. Judge Okafor took it. She opened it to the first marked page. She read the 12-7 entry. She turned 2 more pages. Her expression did not change, but something behind it settled the way a case settles when the last piece of evidence arrives and the picture is complete. She told Webb she needed him available to state investigators beginning that afternoon. He said he would make himself available whenever required. He also said, with a slight hesitation that was the only outward sign of what it cost him, that he had submitted his letter of resignation from the Fairfax County Police Department to his supervising sergeant that morning, effective immediately. She looked at him for a moment. She said, I understand why. That does not make it any less of a loss. 2 officers from the Virginia State Police Internal Affairs Bureau had been paged by the court clerk while Drummond was still presenting the MDT logs, because court clerks who have been doing this work for many years recognize when something needs to be in motion before the proceeding concludes. They arrived and waited in the back of the gallery until the dismissal was entered, and then walked to the front row and asked Crowell politely to come with them. He went. He did not look back at the room. The side door closed behind him, and the room let out a collective breath that was not relief exactly, but the release of something that had been held tightly for the duration of the preceding hour. In the private office behind the courtroom that Judge Okafor offered, Roland changed into his charcoal Brooks Brothers suit, the white shirt with the French cuffs, the crimson silk tie Evelyn had given him for their 30th anniversary, because she said it was the color of someone who intended to be seen. He put the suit on. He tied the tie. He looked in the mirror. He reached up and adjusted the cufflinks, and he adjusted them high on the cuffs, so the cuffs sat at the top of his wrist. The bruises were visible below the cuff line, both wrists the full dark circumference of where the metal had been angry purple shading into blue. He looked at them. He pulled the right cuff half an inch higher. Let them see. The obsidian Lexus was in the courthouse parking lot. Webb had arranged for its retrieval from impound before 8 in the morning and had driven it over himself. And he had stopped at the point on Georgetown Pike where the stop had happened and retrieved Evelyn's prescription bag from the gravel where it had blown off the hood overnight, slightly damp but intact, and he had placed it on the driver's seat. Roland found it there when he opened the door. He picked it up. He looked at his watch. It was 9:41. He had 19 minutes. He got in the car. He started the engine. The cabin was warm within 30 seconds. He drove north toward Washington. The drive from McLean to the Supreme Court building on First Street took 31 minutes, which required the kind of sustained focus that had very little room in it for anything else, and the absence of room for anything else was not entirely unwelcome. He arrived at 9:58. He parked in his assigned space. He walked through the side entrance and down the corridor to the robing room, and the marshal at the entrance looked at Roland's wrists and started to say something, and Roland gave him one small shake of the head, not unkind, just definitive, and the marshal held the door. Chief Justice Leonard Groh came into the robbing room and looked at Roland's wrists when Roland reached for his robe, and the expression that crossed his face was one Roland recognized, the expression of a person putting together a picture from visible details and arriving at a conclusion he needed to be very certain of before he said anything about it. Roland pulled the robe on and settled it on his shoulders. Groh came to stand beside him and said, "Roland, he said it the way you say a person's name when the name is carrying a question that does not need to be stated in full." Roland looked at him. He said, "I am fine." And he said, "Leonard, I need you to let the arguments proceed without interruption. Whatever you read in the next few hours, whatever calls you receive, let the morning proceed. It matters that the morning proceeds." Groh studied him for a long moment. He looked at the wrists. Then he said, "All right." They walked out together at 10 in the morning through the red velvet curtains into the chamber. The chamber was everything the detention facility was not: high ceilings and marble, and the particular quality of light that comes from tall windows in a room built to last centuries, and the smell of wood polish and old books, and the specific austerity of a place that has been taking the measure of the law since 1790. Roland took his seat. He placed his hands on the bench surface and looked out at the attorney standing at the podium. The bruises showed above his cufflinks when he reached for his glass of water. He had arranged the cuffs high, and he did not adjust them lower. 3 seats to his right, Justice Miriam Cole noticed within the first 5 minutes. She was 58 and had been on the bench for 7 years, and knew Roland's physical habits as well as you know the habits of anyone you spend 100 days a year seated next to, and she looked at his wrists and then looked at his face with a question she kept completely off her features because they were on camera and the decorum of the proceeding required it. Roland did not look at her. He was reading a brief. He asked his first question at 10:14, and it was the kind of question that made the attorney at the podium pause for a full 3 seconds before answering. Not because it was hostile, but because it was extraordinarily precise, going directly to the one unresolved tension in the argument that the briefs had not yet fully addressed. He thought about Terrell Boyd twice during the hour, not as a distraction, but as a compass bearing a reminder of what the abstract principles in the argument were made of when you stripped away the procedural language and looked at the core. The story broke at 11:52 while the second argument of the morning was still proceeding. Roland knew this because Justice Cole's phone lit up 3 times in 4 minutes with the frequency of a device receiving alerts on the same story. He did not look. He asked another question. By noon, when the morning session ended and the justices rose, every phone in the building had received it in some form. The photograph which someone in the gallery of courtroom 4A had taken on a phone at 8:21 and posted without comment was on the front page of every digital news outlet in the country. It showed a man in a white undershirt and sweatpants and ankle shackles standing next to a man in a bespoke 3-piece suit, and the man in the undershirt was standing with a posture of such complete and deliberate authority that the shackles registered as an afterthought and the bruises on both wrists were clearly visible, and the man's face was the face that appeared on the Supreme Court website under the heading Associate Justice Roland Mercer. The caption someone had given it was 6 words: he was going to pick up medicine. By 2 p.m, the Fairfax County Police Chief and the county mayor held a joint press conference at which both men appeared to have aged significantly in the preceding several hours. The chief announced the immediate termination of Officer Wayne Crowell, effective retroactively, no administrative leave, no union protection. He announced the retirement of Captain Hal Greer, who had supervised Crowell's division and whose name appeared on the signature line of 21 dismissed complaints effective at the end of the business day. He announced a full independent review of the department's discretionary stop procedures and its internal complaint review process. He did not take questions. Roland watched none of it. He was in his chambers writing. 3 weeks after the press conference, the Department of Justice announced a federal criminal indictment against Wayne Crowell under 18 United States Code Section 242, deprivation of rights under color of law, with additional perjury charges arising from the sworn affidavit he had filed in Fairfax County Courthouse. The indictment moved with a speed that federal proceedings rarely achieve, and the speed was directly traceable to the fact that Roland had, by writing the arrest all the way into an arraignment, created a complete public record in which every violation was documented, sworn to by the perpetrating officer, and witnessed by a judge, 2 attorneys, a prosecutor, a court reporter, and approximately 45 other people who had all been in courtroom 4A that morning. The federal sentencing hearing 8 months after the indictment took place in a courtroom that smelled like too many people packed into it with significant stakes riding on the outcome. The gallery was full. The press pool had its own section. 3 of the families whose complaints had been dismissed by Captain Greer over the previous 7 years were in attendance. Some having driven 200 miles to be there, and their presence in the room had a quality distinct from the presence of the reporters, something quieter and weightier, the presence of people who came not to watch a story, but to see the end of one. On the second day of proceedings before the sentencing, the federal prosecutor dimmed the courtroom lights and played the audio from the dash cam of Cruiser 7 Delta. The recording began with road noise, the hum of the engine, the faint percussion of rain on the roof of the car. Then Crowell's voice, clear and unhurried, speaking to Webb in the cruiser before the stop was initiated. Neighborhoods like this have an ecology. Marcus and my job is ecological management. Some things belong here and some things do not. Then, 3 minutes later, the moment at the driver's window, guys who look like you do not own cars like this in neighborhoods like this. That is not something I need a computer to tell me. That is something I know. The recording ended. The lights came back up. Crowell sat at the defense table with his head slightly bowed. He did not look at the jury. He did not look at the gallery. He did not look at the families in the 3rd row who had driven 200 miles. He stared at the table surface in front of him, and he listened to the silence that followed the sound of his own voice, and the silence was complete. The prosecutor said nothing for 10 seconds. She did not need to. The recording had said everything. Crowell sat at the defense table in a suit that did not fit him well, purchased under duress by a man who no longer had an income and a credit card approaching its limit. The swagger was gone. The jaw was still. The man who had tapped his badge with 2 fingers 10,000 times over 14 years sat with his hands flat on the table in front of him, and there was nothing in those hands. His attorney argued mitigating circumstances, 14 years of service, a difficult assignment, stress and poor judgment, a single moment that escalated beyond what was intended. Judge Margaret Holloway, who had been on the federal bench for 16 years, and who the legal community described as having the patience of a person who had never needed patience because she had simply always been right, let the defense attorney finish without interruption. Then she picked up a document that was 14 pages long and began to read names. She read the names of 23 people who had filed formal complaints against Wayne Crowell over 14 years. She read not just the names, but a single sentence for each drawn from the complaint itself describing what had happened to them in a specific stop on a specific road on a specific date. She read them in chronological order, beginning in the year he was assigned to the McLean corridor, and she read steadily and without editorial comment, and the room was completely quiet for the 11 minutes it took to read them all. When she finished, she set the document down and looked at Crowell. She said, "You were not a man who made a single poor decision under pressure, Mr. Crowell. You were a man who made the same decision in the same way for the same reasons for 14 years. You built your career on the certainty that the people you stopped would not be believed, could not be heard, and would not have the resources to follow you into a courtroom. You were right about almost all of them. You were wrong about one. And that one has brought all 23 of them into this room today." She paused. She let that land. Then she said, "Stand up, Mr. Crowell." He stood. The motion was effortful. The hands that had tapped a badge 10,000 times now gripped the edge of the table briefly before releasing it. "Under the federal charges of deprivation of rights under color of law and perjury before a court, I sentence you to 8 years in federal prison," Judge Holloway said. "I order $340,000 in civil damages to be paid personally with a portion of your police pension fund liquidated toward the judgment. The remainder of that pension is hereby redirected to a legal defense fund for low-income motorists facing civil rights violations in the state of Virginia." She paused once more. "The fund will be called the Georgetown Pike Legal Defense Initiative." She named it from the bench, so it was on the record and in the transcript and could not be quietly changed later. "Furthermore, you are permanently barred from employment in any law enforcement capacity in any jurisdiction." The gavel came down. In the third row of the gallery, a woman named Patricia, who had driven 212 miles from a town in the Shenandoah Valley, because Wayne Crowell had stopped her husband 3 times in 1 year, and the third time her husband had been taken to the hospital, and no one had been charged, and nothing had ever happened. Exhaled slowly through her nose, the long, steady exhale of a person releasing something she has been holding for a very long time. She did not smile. She simply breathed. The marshals approached Crowell. They turned him and cuffed him, and the ratchet clicked 3 times, each click precise and deliberate, and the sound in the courtroom was the same sound it had been on a dark Virginia roadside 8 months earlier, on a wet shoulder of Georgetown Pike at 12 minutes past midnight. The same 3 clicks, the same cold metal, just on different wrists this time. As they walked Crowell toward the side door, he looked back at the gallery one time. He found Webb in the second row. Webb was looking at him, and Webb's expression was not triumphant and not sympathetic, and not much of anything except honest, the expression of a man who chose to do a hard thing when it was required and has made his peace with the cost of it. The side door opened. Crowell went through it. It closed behind him, and that was the last anyone in that room would see of the officer from Cruiser 7 Delta for 8 years. Marcus Webb testified at the federal proceeding with precision and corroboration from every piece of documentation he had preserved, and the federal prosecutor commended him publicly in her closing argument as an example of what integrity in law enforcement actually looks like in practice rather than in recruitment materials. Afterward, a DOJ civil rights attorney approached Webb in the courthouse hallway and asked whether he had ever considered federal service. She gave him a card. He asked for the materials. He submitted the application 6 weeks later. Captain Hal Greer retired to a house in the Shenandoah Valley and was never charged with a crime which was the one outcome of the proceeding that did not satisfy Roland, and which he noted in writing in his chambers, with the intention of addressing it in a different forum at a later date. Because the men who build and maintain the machinery of impunity are as responsible for what the machine produces as the men who operate it, and the law had not yet adequately articulated this principle, and Roland had some thoughts about that which he intended to put on paper. Crowell sold the house before sentencing because the civil judgment required it. The retirement fund was largely gone. His marriage had ended before sentencing. He moved into a 2-room rental in a county 2 hours from McLean, and he lived there for 11 days before he was transported to the federal facility. Roland read the sentencing order in his chambers on the afternoon it was issued. He read the names Judge Holloway had listed. He wrote each one on a yellow legal pad in his careful, precise handwriting. He had a list of names that he maintained from his years as a public defender, names of clients he intended to remember because they deserved to be remembered. And this list had been added to periodically over 40 years. And he added these 23 names to it, and then he sat for a moment looking at the paper. He wrote one more name, Bobby. He still did not have the last name. He intended to find it. Wayne Crowell walked into the federal processing facility on a Wednesday morning in January wearing a gray t-shirt and dark pants, and the corrections officer at the intake desk asked him his name and what he had done. The standard intake question asked 40 times a day without looking up from the form. Crowell started to answer. He said something about a traffic stop, about a neighborhood, about the kind of car and the kind of driver and the way things worked on a road he had patrolled for 14 years. He was not defensive about it exactly. It was more that the answer he had always had was still the only answer he knew how to give. Even now, even here, even stripped of the badge and the uniform and the cruiser and the backup and every other apparatus that had made the answer feel like a fact rather than a choice. The intake officer stamped his form. The stamp sounded like a gavel. He said cell block 4, bunk 12, and pushed the form across the desk without looking up, and the correctional officers on either side of Crowell began walking him forward, and the desk receded behind him, and the door to the processing corridor opened and closed. 3 months after the sentencing, the Fairfax County Police Department issued a standing departmental order that required all officers initiating discretionary traffic stops to log a documented reasonable articulable suspicion into the mobile data terminal before activating lights or sirens, with the log entry time-stamped and supervisor reviewable in real time. The policy was entered into the official record as Order 7 Delta, which was the call sign of the cruiser that had stopped a Supreme Court justice for driving his own car home on a cold November night, and the naming of it that way was deliberate and on the record. In the first 6 months after Order 7 Delta took effect, the discretionary stop rate for black drivers in the McLean corridor fell by 61%. The figure was cited in a footnote in a law review article published the following spring. The law review article was cited in 2 lower court opinions. Those opinions were cited in a petition for certiorari that arrived on Roland Mercer's desk the following winter. He accepted the case. On a cold morning in February, with the dome of the Capitol visible through the window of his chambers in pale winter light, Roland Mercer signed the majority opinion in the case of Boyd versus Commonwealth of Virginia, which established a new federal standard requiring documented reasonable articulable suspicion for any discretionary traffic stop and creating enforceable accountability for departments whose records showed deeply embedded patterns of discriminatory enforcement. The opinion was 42 pages long. The opening paragraph, which legal commentators would later describe as the clearest statement of Fourth Amendment principle written in the previous 50 years, had been composed in his head in a concrete cell at 12:45 in the morning in yellow light on a cold floor, while a stranger on a bench slept nearby and the bruises on his wrists were still forming. He set the pen down on the desk. He looked at his wrists. The bruises had been gone for weeks, but he looked at the place where they had been anyway. The pale, smooth skin above the cufflinks, and he stayed with that for a moment, with what it had felt like in the dark and the cold, with the weight of the floor through the thin sweatpants and the sound of the cell door closing, and the quiet human decency of a stranger asking without asking if he was all right. He had been all right, not because of the suit in the closet or the phone number for Calvin Drummond or the appointment with lifetime tenure. He had been all right because he had decided to be, and because the decision had been in service of something larger than his own relief, and because 40 years of standing next to the men the machine tried to grind up had given him in the end one night on the floor with them, and he had used what he learned there. He pushed back his chair. He stood. He straightened his tie and reached for his robe. Outside the chamber door, the marshal was waiting. The next case was ready. The work continued. If this story opened something in you, if it made you feel the weight of what justice actually costs and what it is actually worth, then please take a moment and hit the like button right now. Share this video with someone in your life who needs to hear it today. Someone who would understand why a man with every reason to take the easy way out chose not to. Subscribe to our channel so you never miss the next story, and drop a comment below telling us what you would have done in Roland Mercer's position. Would you have stayed quiet? Would you have said your name? The conversation matters, and we read every single one. We will see you in the next story.